There, good morning, everybody. Welcome to the webinar, Estate Planning Basics. My name is William Ha. I'm an estate planning attorney. I do wills and trusts, and I want to commend you guys all for being here today, the day after Thanksgiving. In the times I've hosted these, I can never figure out what's a good time and date because people seem to have better things to do than to learn about estate planning. So I think for most people, at least at this time of the hour, people don't have anything scheduled. So thank you again. So for the next 45 minutes, I do want to share the concepts that you may or may not already know. There's a lot of misconceptions floating around. So I do want to lay out some of the common issues as to what could go wrong without estate planning, the planning that you guys will need, and then how to get them in place. So if you guys made the commitment to show up today, it's best to do what the kids say today, and that's to really lock in. The knowledge that you get today will come in handy, not only for your own estate planning, but really for dealing with, like, say, your parents' estate planning or your family's estate planning with time. I think if you guys happen to recognize the problems and solutions, it's really just practical knowledge. And there is a Black Friday element to this webinar. So if you guys stick with me for the entire webinar, I will reveal what the offer is. So estate planning is not really a very exciting topic. In fact, I've had people tell me what I do personally is boring. Okay. So it's almost like doing taxes, but instead of doing it yearly, it's only done maybe a handful of times during a lifetime. So I understand the struggle. The reality is that most Americans have no estate plan at all. I'm talking no will, no trust, nothing. One misconception about estate planning is that it's going to take too long. You don't know how long it will take. And I get this hesitation. So I'm going to address those concerns. So that way, by the end of the webinar, you'll know exactly how long the process will take, what's involved, and then how much it costs by the end. And this is our agenda. This will be the knowledge that you'll be able to take with you. I know some of you guys are parents of minor children, so we'll cover how to nominate people to take care of them if you pass while they're still minors. We'll also talk a lot about the probate process and how you can avoid it. If you have no idea what probate court is, don't worry. I'm going to go over that later in the webinar. And then a really common question I get is that what's the difference between a will and a trust? So by the end of the webinar, you'll have a good idea as to what makes sense for you and your family and what they both are. We'll also talk about some basic asset protection for your kids so that they don't easily lose their inheritance through a divorce or bankruptcy, and that they don't get a big check on their 18th birthday. So I'm going to aim to speak for about 45 minutes, and then I'm going to reserve a bit of time for the questions, but I might just run this through even faster. I know it is Black Friday, so you guys have things to do. A little bit more about myself. My name is William Ha. I'm the founder of William Ha Law. I have a small law practice based in Whittier, serving LA County. But with technology these days, my clients are actually all over the state. I'm also licensed in the state of New Mexico. So what I do in this firm is estate planning, which is drafting and planning the estate. I do the probate, and I also do trust administration as well. This is my contact information. Feel free to call me or email me if you have any questions at all. But the best way to get a hold of me is through email or by booking a short 15-minute call through my website. Okay, so we spoke earlier about how most people don't have an estate plan, or at least they don't think they do because they haven't done anything formally on a will or a trust. But the truth is, you do have an estate plan, even if there are no formal documents. The state of California actually has default rules for what happens to your stuff if you don't have a plan in place. You probably won't like the default rules, or the default rules may result in something unexpected, which is why we do estate planning, so that we can override the default rules for your family and assets. You get to make these important decisions yourself, as opposed to letting a state do that for you. Okay, so when you die without a will, you're doing something called dying intestate, which means that this is the do nothing scenario. It means you end up with California's default plan. So what is the default plan, right? So in California, if you die without a will, the assets are going to be distributed to according to state law, and this could go to people you don't want. It's just basically the rules of intestacy. It goes to your next of kin. Your kids get an inheritance outright at 18. Um, if your spouse remarries after you die, they might leave money to a new spouse and kids. A judge is going to step in to decide how to figure out who's going to be parents of your minor children. And then probate court is basically guaranteed because you've died intestate, and probate has to be opened up to basically establish the authority over that estate. And this question here is specifically for young parents on the call. If you happen to have minor children, that is kids under 18, one of your top priorities is getting in writing who you want raising your kids if should something happen to you and your spouse. So if your kids happen to be on their own through death, there will have to be a permanent guardianship proceeding, and basically a friend or a family member would have to petition with the court for custody of your children, and the judge will have to make the final decision as to who's going to raise the kids. This kind of proceeding is, really rigorous, complicated, takes a long time, and it's expensive. So the obvious and quick solution, good solution, is to get a will. Basically, in the will, that's where you conventionally, traditionally nominate your first choices for guardians, right? So if it's a couple, you want to say what happens if they get a divorce or if one of them dies. You may name your sister and then her husband, but if your sister dies, do you want the kids to go to your husband? Maybe, maybe not. You just have to write it down. It has to go in the will. You can list as many backups as you want. And then if your first choices are not available or they end up declining the appointment, at the very least, a judge will have somewhere to work off of, which is why if you know for a fact that your sister or your mom would be a bad person to be a guardian, you may want to nominate your friend that you're really close to, that your kid's really close to as well. So this is one of the things that will allows young parents to do, and the will is typically where you nominate your choices for guardians. Okay, so what about your finances, right? We talked briefly, about guardianship through using a will, but what about your assets? Like, how does that work? Okay, so what's an estate? So first of all, the legal definition of what an estate is very different from the common usage of the word. People tend to think of an estate, they think of like a really sprawling piece of property or a lot of assets. But the reality is that when you pass, if you own anything in your personal name, those things legally become your estate. So this could include the checking account that you happen to have, your vehicles, your brokerage accounts, digital assets like your email, cryptocurrency, the house, retirement accounts that, happen to have no beneficiary designations, your jewelry collections, your business interests, any intellectual property that you have. When you own things in your personal name, these things become your estate. And the state of California, will have a plan for you to dispose of these things if you don't have like a will that overrides the default rules, right? So who ends up getting these assets and how much depends on if you're married and if you have kids. I do want to clarify something. Like when I say owning things in your personal name, that's the default. Like when I buy things or when I open up a checking account, typically you have in your personal name. Non-personal name setups could be, owning things through an LLC or owning things in a trust, which I'll go over later on. But by default, most people own assets in their personal name. So this is really your choice when you're doing estate planning. People generally go with one or two options. They either decide to do a will-centered plan or a revocable living trust-centered plan. This is the decision that people make when they do estate planning, and this is what they have to go through. Whether they're married, have kids, don't have kids, regardless of how much money they have to ultimately decide whether or not they want to do a trust or a will. There are pros and cons. I think option 2, a trust, is very common these days, but there are some administrative downsides that people don't really think about as you're doing it, right? So it's not a full panacea, but generally speaking, most people do decide that having a trust is superior to having a will, and I'll explain further as to why that is. Okay, so let's do a deep dive as to what a will does. Okay, so having a will is better than having nothing. So number one, it's where you name your guardians for your minor kids. You could also name beneficiary for any asset or account held in your personal name. You get to also name executors, which are people who are nominated to be in charge of wrapping up your affairs and estate when you're gone. They're the ones who hires the probate attorney. They're the ones who interface with the court, deal with the creditors. So that's what a will does, right? But that's also mostly what a will does. It allows you to nominate guardians and also allows you to kind of decide where assets go and who to nominate to interface with the court. But it does nothing beyond that. So if you're fine with this can work. I think people with simple estates, they can go through a will, especially if the probate is anticipated to be fairly straightforward. But there are actually no guarantees. Okay, so this is kind of where a will fails. So there are some pretty downsides to having just a will. As I mentioned before, wills have to go through probate court at your death. And we'll talk about why this is, why probate court's bad in a couple of minutes. A will is only effective at your death. So it doesn't help at all if you're alive but disabled and you can't manage your own affairs. What happens if you're incapacitated and you can't pay your own bills or communicate your health wishes, right? What happens when people start taking advantage of you and your assets? Elder abuse is a thing, and you actually don't even have to be old. I mean, if anyone remembers the founder of Zappos, Tony Hsieh, near the end of his life, the people controlling his assets, they were his friends who happened to be on payroll. Okay. Most parents actually don't want their kids to inherit everything when they turn 18, and this is the age in which you're legally entitled to inherit money. So in a case where there is a will and there are minor kids, like there's going to have to be a minor's account, and a judge will likely need to be involved to figure out who's going to manage that account for that minor child. A lot of assets actually are outside of the reach of a will, and they often go unplanned for, right? So wills actually don't control a lot of property, including retirement plans, annuities, insurance policies, and anything that's held jointly with somebody else, say a joint checking account or property that's owned like jointly. And this is fairly common, like when you own property with your spouse as joint tenants with right of survivorship. A will does nothing to that ownership at all. In fact, it actually just kind of operates according to law. So survivor in that case would take it, but a will would do nothing in that scenario. And then lastly, a will simply transfers property at death. Like you can't say, I want my money to go to my daughter when I pass away. And you can't say only when she's 25 and only when she's finished college, right? You can't put those conditions in the will for how and when the money is spent for your children and grandchildren. To do things that are way more sophisticated and having some control over the assets, you actually need a trust for that. So this is a oversimplification, but if there's a will and there's only a will, then you can guarantee that there's going to be a probate. And if there's not a will, there's going to be a probate anyway. But yeah, a will, probate. And I think a lot of people have this misconception. I've worked with probate clients who thought they took care of everything by having a will. All they've done was just override the default rules, but they did not opt out of probate at all because there were assets owned in their personal name still. Okay, so let's talk about probate then. So there are really three big downsides to probate. Number one, it's expensive. It can take a long time. It's also a public process. And probate court's real court, and like any legal proceeding, it involves hearings, lawyers, time, and money. So basically, the main purpose of probate is to change the title on property you own to someone else after you died. So a full inventory of assets has to, be cataloged. Notices to creditors have to be given. If there are any creditors, they have to submit proofs of claims. Those creditors who file timely claims within the statute of limitations are paid out. And then if anyone contests the will, that could happen, that gets sorted out in probate court as well. Whatever is then left over is then distributed to either your heirs or your beneficiaries. Heirs are just next of kin. Beneficiaries are people you've specifically nominated in the will to receive the assets. Okay, so how expensive is probate, right? So there are various fees associated with probating a will, court fees, lawyer fees, executor fees, and the range is that this eats up roughly 2 to 7% of the assets, and it really depends on the size of the state. There's a scale that's calculated for how much people have to pay the probate attorney and also the executor. But the fees are going to reduce the amount of money that ultimately goes to your family. And if there's actually not very much liquidity, then this becomes a big issue because then like you may need to borrow money to pay some of these fees to people. So this is a hypothetical calculation of probate fees on an estate that's worth $4.7 million. So the exposure ends up being $121,000. Half of that will go to the probate attorney, and then half of that will go to the personal representative that's nominated as executor in the will. This also doesn't include like the court filing fee or the probate referee fee. So hypothetically speaking, a really common probate I do is roughly $1 million. Simply because that's how much the house typically is worth. Doesn't matter if there's a mortgage still on it. The fact that it's worth $1 million means that's calculated $1 million. And the attorney fee on that is generally roughly ballpark $21,000. So if your personal representative you nominated elects to collect the fee as well because they're doing all the work as well, they'll get the same amount. So something to keep in mind when it comes to probate. Just think about how there is a fee, it's paid at the very end, but it will cost you. It will cost your estate. And then probate is time consuming. Even the simplest estates that are required to go through probate, the shortest will be 9 months. But the reality is that it takes about a year and a half. During this process, your assets are frozen. If there's a problem, and this is a problem, if you're counting on the money, available for the care of children, for example, this is a really difficult thing that you have to go through and sort out. I mean, do you borrow money from the house? Do you ask the judge for special permission to do this prior to the final distribution is done, right? So this is a huge emotional burden on your family. And if you need something to happen, what you don't want is you don't want to go through probate. Okay, so probate is public. You can literally walk into the probate courthouse in downtown, and then you can watch the hearings. You could pull up all the documents filed to see what has been happening in the case. You could see people's actual wills. You could see who is going to get what and how much. All that's stopping anyone from doing this is just the nominal fee that they have to pay to do a record search. Anytime I file probate, my clients get so many calls and so many letters from solicitors trying to offer them some sort of odd service, scammers end up calling people. So probate, even though it's kind of like behind like a thin wall, it's still public record that anyone can look into to see what's happening with the estate and what's happening with the final distribution. Okay, so I mean, I talk a lot bad about probate, but I think if it's straightforward, it's actually not so bad under certain conditions, right? So when is a will-based plan appropriate? Okay, so the answer is that if the estate size in California is less than $208,850, $208,850, then you're actually eligible for a simplified probate process that's very easy and inexpensive. So it's still technically it's still technically probate, but it's not a formal probate. It's actually a more simplified version of it. It's, it gets done in like months as opposed to like years. If you happen to have an estate that's under this amount, then a will may be sufficient. Okay. If your gross estate is more than this and it meets that threshold, then it means that a full-blown probate has to be done in probate court. So really, if you don't have too many assets, then I think having a will-based plan where you do the advanced healthcare directive, the power of attorney, the will, and then you take care of, your insurance payouts. I think that could work out. But if you're over that threshold, the money is going to get locked up, and you will need to figure out, hey, if you don't want probate, you need to figure something else out. Say, okay, so this is the second option. This is called a living trust, revocable living trust. This option is basically how most people choose to do when they do estate planning. It's actually quite common now, I feel like. Whenever people do estate planning, they're typically going to be getting a trust done. Okay, so what is a revocable living trust? Okay, so it's a legal document that you create that's kind of similar to a will, right? You list the people you want inheriting your money when you're gone. And just like a will, it's revocable, which means that it can be changed or revoked in its entirety at any time. And also in the trust, you're going to have the role of the trustee. You get to nominate who's going to manage your assets after you, okay? But initially, when you do the trust, that's typically you. You're in charge of both the trust document itself and the assets that go into the trust. And how a trust works is like this. Okay, so you sign and create a document. You're going to give your trust a name. Maybe it's named the Jones Family Trust. Okay, so everything you own is outside of the trust. And after you create this trust, you want to move those assets into the trust by retitling them. So, for example, you have a house. You've already created this trust. You then just grant the deed to yourself as trustee of this revocable living trust that you've created. By doing that, the asset is formally held in trust, and it's not held in your personal name anymore. While this is happening, and while you have this trust that's revocable, it's a grantor trust, which means that you have total control of the assets. You can still use them, spend them, sell them, nothing changes. The taxes are also done the same way. The IRS has a provision for grantor trust. Okay. But the benefit of having this asset or your assets in the trust is that everything that's associated with the trust goes to your named beneficiaries without having to go through probate. And the reason why this works is because you technically no longer own this asset in your personal name. You hold it in trust as trustee. When you die, there's a successor trustee who takes over. So I read an article on Wall Street Journal yesterday about the uber wealthy and how they're setting up these fancy trusts. So you might be thinking too, like, aren't trusts only for the rich? I've had more than one client tell me that they won't want to trust unless they had a big estate or a sprawling property, but it's a really common misconception that trusts are only for the wealthy. So let's take another stab at this. Like, what's a trust, right? So a trust really, it's just an agreement that spells out the rules you want followed for the assets owned by the trust when you pass away. It's really an agreement for how to manage property. It's like basically like a set of instructions, meaning when I die, these people get these assets. You could get more sophisticated instructions, sure, but really it's just an agreement between different people who may end up taking over for how to manage assets. A trust typically solves all the problems that people actually assume are solved by a will. So let's do a trust example, right? So let's go John. He has $100,000 in the bank account, and he wants it to go to his son Fred when he dies. But John wants Fred to be 25, and he wants him to have finished college before he gets that money. To accomplish this, John actually needs a trust. So he's not wealthy. He's not setting something up fancy because he's trying to leave millions behind. He's just putting some rules and conditions in place. He wants Fred to be 25 before he inherits, and he wants him to go to college. So he needs a trust because he wants to control how and when his son gets the inheritance. That's it. It provides a person with something called dead hand control. So in every trust, there are three roles. There's the grantor, and that's the person who contributes and creates the trust. There's the trustee, the person who manages the trust assets. And then there's the beneficiary, the person who's entitled to the assets. When you create a revocable living trust, you occupy all three positions. You're the creator, you're the grantor, you're the trustee, you're the beneficiary. It's this legal arrangement that allows everything to still operate normally while you're still alive. It's not until you die or until you become incapacitated in which these roles end up merging, or I'm sorry, um, shifting to other people. So let's look at another example. Okay, so you have Harry and Wendy, their husband and wife. They set up a trust and they occupy all three positions as co-trustees, co-grantors, and co-beneficiaries. They have total control of this trust. Um, they occupy the role of grantors. They create the trust and they transfer title to their assets to the trust. And they occupy the manager's role as trustee as people who make decisions for the trust assets. And finally, they're also the beneficiaries of the trust in that they have the right to spend and use the trust assets however they want. They have complete control, even though the assets are held in trust by someone by themselves as trustee. Nothing really changes. The beauty of it is that they can amend their trust or revoke it however they want. They have all the rights to manage the property. All the income taxes are filed the same way. So because it's a revocable trust, the government, the IRS, ignores the trust for tax purposes and continues to tax Wendy and Harry as individuals. The analogy that people use that I've used in the past too is that a trust is like a backpack. It's not a perfect analogy, but I think this is good enough to let people understand how it kind of operates, right? So when your kids start school, they could pick out that backpack. It could be any sort of backpack, right? They could pick out like a certain color, a certain size. There's a million options, and there's more than one compartment for different purposes. So a trust is very much the same way. It's kind of like this vessel that holds things, right? You set it up and you accomplish so that you can hold certain things and it accomplishes what you want. So the goal is to have your trust hold all of your assets because those assets will then be distributed to the terms of the trust when you pass away. Um, so it's capable of holding things. It's a vessel. You move all the assets into the trust. So pass away, everything held by the trust or by the backpack, it goes to your family without probate court involvement. You could think of probate court as a way of cleaning things up that are left behind, that are left outside of the backpack, unclaimed, basically. So this is bad. This is an empty backpack. This is equivalent to having a trust that's empty. It's a bare bones trust, and there are no assets associated with the trust at all. This is actually fairly common. People set up trusts and they don't understand the importance of funding it, and then they die with minimal assets related to this trust. Or maybe they initially funded it with their house, their property, but then when they refinanced it, they took it out of the trust. The bank made them put it in their personal name, sign the paperwork to refinance, but they never put it back into the trust. When that person dies, it would have to go through probate because you have this empty trust and they have this house that is in that person's name. Now, obviously, this is good. This is a sign of a well-funded trust. It has things in this backpack. So a trust solves all the problems that come with a will, right? You won't lose off the bat 1 to 7% of your estate in probate court. Assets, they go to your family in weeks, not years. And it's totally private during your life and then at death. And then one of the big reasons why having a trust is important when there's young children involved is that a trust allows funds to be transferred much sooner than a will would because probate court's not involved. So in a situation in which you have nominated guardians who are out of state or even out of the country, like this difference can mean the world because it will require a lot more resources and efforts to petition for guardianship from a different state or from abroad. Having the ability to have funds accessible to people who are important in your life is very, very meaningful in this particular situation. Okay, so let's step away from the wills and trust question. I think by now you kind of have an idea as to like what you like and what might make sense for you. A second big issue I want to talk about is how you're going to design this trust. What do you want it to accomplish? So a very popular, common request I get is that people want their trust, parents want their trust to accomplish is that they want to make sure that the money is left to the kids and it's not spent unwisely, or they don't want it completely blown, right? And let's look at a couple of things that parents worry about when they're gone. Like they worry about how they're going to leave money to their kids, and they don't want their children to commingle that money with their spouse, so that they lose half of it in a divorce. Or they're worried that their kids will lose the inheritance through a creditor lawsuit or bankruptcy. And these are some real possibilities if you give your kids a big lump sum outright on their 18th birthday. So let's talk about this. So Harry and Wendy, the couple, go back to that example there. They got two grown kids. They got Denise and Sam, right? So Harry and Wendy, they've taken no steps to ensure that wealth is not wasted once they're gone. This is because they have simple wills, which just dumps a huge windfall to both Denise and Sam. So Harry and Wendy are leaving behind $2 million in this case. Denise and Sam each receive $1 million from Harry and Wendy. Okay, so Denise is married to Jason. Like Jason's got a ton of business ideas, but just doesn't execute and has, not brought in very much money since he's been married to Denise. Denise gets that $1 million inheritance and dumps the entire thing into a joint checking account with Jason. It's true that generally in California, if it's an inheritance, it's presumptively separate property. But because she has commingled that money into a joint account, and it's commingled with community property funds, the inheritance money is then exposed, right? And then when they get divorced 5 years later, Jason potentially is entitled to half of that money as part of the community property division. And this is the last thing that the parents probably want. I know that for a lot of my clients, like they come to me, they tell me that they get along with the in-laws. But then like when the marriage happens to end through a divorce or they're going through a separation, things obviously shift very quickly, right? And so I think like it's definitely a thing that parents don't want their kids to have to go through, losing the parents' money in that way. So Sam, on the other hand, he takes that $1 million, he dumps it into his checking account. So Sam's not married, but he is accident prone, really clumsy. He leaves water running in the bathtub, and he goes out for the night, flooding the condo below his. So the downstairs neighbor sues him, and then Sam loses the lawsuit in the judgment, and he loses that inheritance through a settlement. So, and this is also the last thing that Harry and Wendy would have wanted. Like they worked hard all their lives, and they don't want to lose. They don't want Sam to lose everything in a lawsuit, right? Through a creditor lawsuit. So, what's the solve for this? What's the solution for this? How do you avoid kids from losing everything through divorce, lawsuits, or bankruptcy? So the solution is something called the Children's Trust. Basically, instead of giving assets to them outright, you give it to them in a trust. It's kept in a trust, and this is almost like a freebie. This is a way to give your beneficiaries some simple form of asset protection um, as part of an irrevocable trust through your death. This is actually a lot harder to do while you're still alive, because most people don't are not willing to pay that price to do an irrevocable trust. You end up giving control of your assets away, but upon death, there is some semblance of default asset protection if you keep things in trust. So going back to our example, Harry and Wendy, they made a mistake by giving the assets to the kids outright. An outright distribution is kind of like squeezing, things from a toothpaste. It's all in one go, right? Money is in their accounts. They could do anything they want with it. It means that this money could be also subject to bankruptcy, creditors, divorce proceedings, or just be spent unwisely. And most estate plans are actually drafted this way. People will typically give assets to their beneficiaries outright. I think there could be a variety of factors for this. Maybe there's not that much money involved, or they just like the simplicity, right? But most estate plans are drafted in which people are giving money outright. So instead of giving their money outright, what they could have done was they could have just kept things in trust, and then each child gets their share of the inheritance kept in trust, and they get to access the principal of the money when they reach a certain age, or when they reach a certain stage in life. For example, a really common setup could be maybe 30% at 25, half of the remaining at 30, and then the rest remaining at 35. And this would ensure that the principal remains protected, because they can't simply just withdraw the money or request a full-blown outright distribution. So and like having a trust set up this way basically ensures that your children don't have full control of that money, so that they they're not subject to a division through divorce or creditor claims. Now let's quickly talk about taxes. So there are three, generally speaking, taxes that people have to worry about. Estate tax is a tax that's due when someone passes away, if you have more than a certain amount of money, and this is a federal estate tax. Most people actually don't have this problem anymore, because the threshold now is $15 million. So any amount that you have over $15 million will be taxed at 40%. Most people are never anywhere even close to that. Also, if you're a married couple, that doubles to 30. Um, Income tax on inheritance, this is often not a problem as well, as long as you plan for it. When you wait until you pass to give the property away, you automatically get what's called a step up in cost basis. So take, for example, a house. Let's say you bought the house in LA County for $100,000, and then when you die, it's worth $1 million. If you wait until you pass to give that to your son, for example, and your son turns around and sells a house soon after you die, the IRS is willing to step up the cost basis to basically equal what you sold it for. If you transfer the house while you're still alive to your son, then you don't get that step up basis. And then when your son sells it, he is going to have to pay some taxes on capital gains. Another one in California here is property taxes. So for a lot of people here in California, they have what's effectively a really good tax rate. It's 1% to start, and then there's some additional assessments. But the good news is that unless you sell the property or make some really major improvements, the state's not allowed to reassess the fair market value in which you initially purchased it for. So through Prop 19, which was passed a couple of years ago, that did get restricted some. But so long as your kids inherit the property and live in the property, they actually get to inherit your original tax basis as well. There is still a bit of uncertainty as to like who gets to claim it and do they all have to live there. But I think this is in a bit of flux, because I think people do think that Prop 19 is actually really unpopular. So, but these are the issues that we typically talk through as we're doing the consultation. So, okay, so you might be wondering, and you may have already considered it, like, why can't I just do your trust online by yourself? Okay, so I think DIY is great for crafts, home improvements, food. It's like things you could experiment with, right? But with estate planning, the issue is that you actually don't see the results of your will or trust until it kicks into effect, either in incapacity or death. So there's actually not very much room for trying new things out or experimenting. You have to get it right in one shot. I'm not saying it's not possible. I've met a lot of people who are smart enough that they could do this on their own, but they would have to be really dedicated to doing it. But there is a ton of risk in doing this on your own as well. And I've definitely seen attorneys get it wrong for their clients too. So um, this is definitely like trickier stuff if you don't have people checking your work, and if you're not an experienced practitioner. Okay, so when you work with an attorney, you're paying for their guidance and counseling, right? It's not about the documents themselves; it's about the relationship. So that's the extra added benefit that you're getting when you're hiring an attorney to doing estate planning. If things need to be changed or if you have questions, an attorney can kind of help guide you through the estate planning process. If you are going to go with a DIY route, it's really just the documents you're paying for. It's a paralegal service. It's a self-help service. So there's actually a lot of things that may not fit your situation. Okay, so the informational program portion of this program is over. And basically you need to get an action plan in place and ask these basic questions, right? So what do you need to do? How do you make it happen? When should you get started? And what's the right investment to get things done right? Okay. So, there are many options out there for attorneys. Like there's no real one size fits all. And then some things you should consider when looking for an attorney is that you want to look to see if the attorney's primary focus is on estate planning. Okay. Does the attorney charge a flat fee? And do they clearly state what you're getting? I think in LA County, like there is a range. There's actually a fairly wide range as to how much attorneys charge for a trust. I've seen attorneys charge like $2,500 to like up to $10,000, right? And if you're looking for paralegals, there might be some paralegals who do it for a couple $100. Like there's actually a really wide range, and there's like oftentimes no rhyme or reason. Like I've seen attorneys who do good work, who charge less. I've seen attorneys that do terrible. They do not the best work and they charge a lot. And then does the attorney have a process to keep the plan up to date? And then lastly, you want to ask yourself, can you see yourself working closely with this attorney? I think estate planning is like really people driven. It's relationship driven. It's all about, whether or not you want to maintain this relationship with this attorney. So something to keep in mind with. Okay, so with my firm, it's really like a six-step process for estate planning to come into existence. The first is you come to this webinar, which you're already here, and you get yourself the basic knowledge you need to understand what the issues are and what the problems are and how to solve it, right? So that's step one. Step two is that you attend a planning meeting, and that's essentially where I go through the questionnaire you filled out, so I give you like a proper analysis to see what some potential solutions are, and in that session you choose the solution, and I should be able to quote for you how much it would cost. This is a one-on-one session with me. It could be done through Zoom. And if you do move forward and you sign the agreement, we then book a follow-up meeting called design session, and this is where we'll drill down into the plan, the actual sophisticated planning on the trust itself, and it becomes really detailed as to what you want, where assets should go, and then when. After the session, we go through a drafting phase where it takes me about 2 weeks or so to give you a draft of your estate plan. I'll also give you a video review that kind of goes through exactly what your estate plan says and does. If you have any revisions or changes you want, you can certainly request it, and we'll change it. And then if you're ready and good to go, you get to schedule a signing ceremony, and then we'll finalize your plan. And it includes some basic trust funding, such as funding and transferring the property that you own to be held in trust. So if you have a house, I take care of that for you as well, along with the recording. And then after that, I offer a complimentary annual plan review. So you're more than welcome to schedule an annual meeting where we talk through your family situation and see if there are any changes that you want to make. And if there are changes that justify doing an amendment or a restatement, then we could then talk about what that might cost in the future. But most people typically don't need a lot of changes. A lot of the estate plans are drafted flexible enough to ensure that it can still accommodate for a new birth or such. Okay, so who is this next peace of mind planning session for? It's for people who've really watched this webinar and they really do want to move forward. People who they don't have an estate plan, or they think that their estate plan is really out of date, right? They want to look to see whether or not they want to do a trust review or maybe even a potential restatement. It's also for people who are living in California or New Mexico. I don't practice anywhere else. So if you happen to be in this webinar watching, thank you so much. But if you also need a referral for an attorney license in your state, I could certainly provide you with that as well. And then this is one of the things you guys have been waiting for. This is the Black Friday offer. So if you schedule your planning meeting session within the next week to take place in the next 2 weeks, you'll be credited $550 towards your estate plan. That will be the discount given to you. And then lastly, you might be wondering, how much does estate planning cost with me? So like I said, it's a range. So it really depends on if you're married, single, what the complexity is. But I would say most people fall under the range of $4,500 to $7,000 flat. Half is due upon the signing of the contract, and then the second half is due at the very end when your estate plan is executed. If you're looking for a will-based plan, that's roughly $3,000. Okay. So I have put in the chat the links that you can fill out. So it's a questionnaire that you get to fill out, and also there's a link to sign up for the peace of mind planning meeting. And you could also scan this QR code here. You're more than welcome to email me. And if you want to ask a very simple question or short call, you get the book. You could book a meeting with me, a 15-minute short call on my website as well. So that concludes the webinar. We're at 45 minutes. Anyone have any questions about anything, feel free to put it in the chat. I'll be here for the next couple of minutes. If there's nothing else, thank you so much for showing up today. It's been a pleasure, and I look forward to working with you and answering any questions you guys have. Then once again, there's a chat box. It should be on the top part of your screen. If you click on it, it should open up a place where you could type in your questions. Okay, if there are no questions, thank you again so much. You're more than welcome to asking the question with me directly by booking a call or sending me an email. And have a good rest of your weekend. Bye-bye.